Public Business, Government Business Bills, second reading.
Minister of Labour.
Mr. Vice President, I beg to move that a bill entitled An Act to Repeal the Foreign Labour Contracts Act, Chapter 8811, be now read for a second time.
Sorry, Minister of Labour, could you, once the booth is cleared?
All right. Mr. Vice President, I thank you for the opportunity to contribute to debate on the Foreign Labour Contracts Repeal Bill 2021. The objective of this bill is to repeal the Foreign Labour Contracts Act, Chapter 8811. Mr. Vice President, the Foreign Labour Contracts Act was enacted on February 10, 1900, as the Foreign Labour Contracts Ordinance. At that time, Trinidad and Tobago was still a crown colony of the British Empire with a governor as its head. The underlying reason for the ordinance enacted, Mr. Vice President, was to curb the massed outward migration of laborers from Trinidad and Tobago, which would have threatened the economic stability of the then colony. I am certain that we all are versed in the history of our country, but permit me to paint the historical context that gave rise to this ordinance. The social and economic conditions existing in Trinidad and Tobago at the turn of the 20th century provided the impetus for the introduction of this ordinance by the colonial government. The working class population of Trinidad and Tobago grappled with bleak living conditions, working conditions, low wages, dismal economic prospects in the early 1900s. Many disgruntled laborers began to seek opportunities in other Caribbean islands. Most notably, Mr. Vice President, was the fact that construction began in the nearby Panama on the Panama Canal. And this project drew thousands of West Indian laborers from Jamaica, Barbados, St. Lucia, and Trinidad and Tobago. It is estimated that between 1881 and 1914, a total of 200,000 West Indians made a journey to Panama in hopes of a better life. The debates in the Legislative Council in the 1900s revealed that the Council originally passed the ordinance to prevent immigration from Trinidad and Tobago to the Panama Canal, since at that time it absorbed many of the hands that were needed in Trinidad and Tobago. This mass outward migration threatened the fragile economy of the colony, and as a consequence, the then colonial government sought to control movement of laborers beyond the shores of Trinidad and Tobago. The current act, Mr. Vice President, Section 3, stipulates that an employer or any person acting on behalf of an employer must not, without first having obtained the written leave of the President, hire any person to leave Trinidad and Tobago for the purposes of being employed in a foreign country. A foreign country, Mr. Vice President, is defined under Section 2 as any country not within the Commonwealth and proclaimed to be a foreign country by the President for the purposes of this Act. The consequence of this was that the Act would remain dormant unless brought into force against a particular country that had been proclaimed a foreign country by the President. Mr. Vice President, the Act itself is only 9 sections in length, and an examination reveals that Section 3 in the main Act is really the relevant and pertinent clause that guides this particular Act. This section really said that you could not leave Trinidad and Tobago to go to a non-Commonwealth country to perform works, and the other subsets of the Act laid out the punitive measures that would occur if you did so. So if someone was found to wanting to leave Trinidad and Tobago and did not get the prerequisite approval, then they could be charged $4,500 and 3 months in prison. Additionally, if they tried it a second time, they would still pay the $4,500 and spend 3 years in jail. Such was the measure of this Act in terms of bringing citizens and towards punitive measures. The Act today, should it be put in force, would mean that all nationals willing to take up employment in foreign countries would have to obtain, as a pre-requirement for their departure, the leave of the President of the Republic of Trinidad and Tobago. Mr. Vice President, thousands of nationals have in the past, continue today, and would seek in the future to embark on opportunities for their own advancement outside of Trinidad and Tobago. A proclamation under the Act could therefore be an infringement to the fundamental rights of freedom of movement afforded to each citizen of this country. At the time of the ordinance original enactment, the original wording stated that a foreign country was a country not within Her Majesty's domain. Consequently, Mr. Vice President, the aim was to prevent Trinidad and Tobago laborers from migrating by keeping them within the British Empire and under colonial rule. However, as the former Secretary General of the United Nations, Ban Ki-moon, once observed, migration is an expression of the human aspiration for dignity, safety, and a better future. It is part of the social fabric, part of our very makeup as a human family. Whilst it is recognized that this is not an unfettered right, any infringement thereof ought to be, as stated in Section 13 of the Constitution of the Republic of Trinidad and Tobago, be reasonably justified in a society that has a proper respect for the rights and freedoms of individuals. Trinidad and Tobago has long since broken the shackles of the colonial past, and this year we celebrate 59 years as an independent nation. The last proclamation made under this Act declared French Guiana a foreign country in 1946, some 7 decades ago. There are no current proclamations under the Act, and thus it is dormant, and so has been for more than half a century. Mr. Vice President, to put it simple, this Act is archaic, and its principles in no way reflect the modern democratic reality of Trinidad and Tobago. Since Trinidad and Tobago gained independence in 1962 and became a republic in 1976, there have been no amendments to the Act. The Act has been absent from the Hansard debates of Parliament, and there has been no recorded public interest with this Act. This seriously calls into question the utility and relevance of the Act today. Whilst the Act has remained stagnant for all these years, Trinidad and Tobago, on the other hand, has developed and progressed significantly since 1900. In the words of William Lacey Swing, former Director General of the International Organization for Migration, migration is not so much a problem to be solved as a reality to be managed. This management must occur within the framework of our fundamental human rights protected at both the international and national levels. Mr. Vice President, on the occasion of Trinidad and Tobago's independence, we became a member state of the United Nations. With membership to this international body, we are bound by the Universal Declaration of Human Rights, which states in Article 13 that everyone has the right to freedom of movement. Furthermore, Trinidad and Tobago is also bound by the International Covenant on Civil and Political Rights of December 21, 1978, which requires countries to respect civil and political rights of individuals, including the right to life, freedom of religion, freedom of speech, freedom of assembly, electoral rights, and freedom of movement as covered in Article 12. To further buttress the point, the principle of freedom of movement has also been enshrined in the Constitution, and Section 4G states, "It is hereby recognized and declared that in Trinidad and Tobago, they have existed and shall continue to exist without discrimination by reason of race, origin, color, religion, or sex, the following fundamental human rights and freedoms, namely, freedom of movement." As a democratic nation, Trinidad and Tobago is founded on respect for rights and freedoms of the individual. Mr. Vice President, the Act came into force at a time when the colonial government feared that a large immigration from Trinidad and Tobago and outside of the British Empire would severely diminish the labor pool. There was work to be done in the oil fields and on the sugar plantations and cocoa estates, and laborers were needed to do this. The ordinance was therefore the solution chosen by the then colonial government to remedy the problems and challenges faced at that particular time. In the 121 years since the ordinance first enactment, Mr. Vice President, Trinidad and Tobago, and indeed the wider Caribbean, have come together to support and encourage the free movement of skilled and unskilled labor. The CARICOM Single Market and Economy Initiative envisioned an establishment of a common economic zone within the region. One of the fundamental hallmarks of the CSME is the promotion of free movement of skilled community nationals and non-wage earners, either as service providers and/or to establish businesses in the nations and countries with which they choose to reside. In this way, trade and investment is facilitated through the Caribbean, and work permits are rendered obsolete for those within the CARICOM region. Since the 1960s, Mr. Vice President, the government of Trinidad and Tobago has encouraged the free movement of nationals to Canada in order to partake in the Canadian Seasonal Agricultural Workers Program. The program provides Canada with a cost-efficient way of sourcing contractual agricultural workers on a seasonal basis to meet the short-term demand for manual labor during the peak planting and harvesting periods. Each year, hundreds of nationals make the journey to Canada for such agricultural work, and the program has been an effective measure in reducing employment within Trinidad and Tobago and addressing the wider issue of poverty. Mr. Vice President, the move to repeal this act is not being made in isolation, and the Ministry of Labor has undertaken extensive consultation with stakeholders. On March 29, 2019, the Ministry hosted a national stakeholder consultation on the review of the Act. Prior to hosting this national consultation, the Ministry sent out invitation letters to 56 stakeholders, inclusive of national and international agencies, government and non-governmental organizations, and to receive comments on the Act. Responses were received from various entities, including the Equal Opportunity Commission, the International Organization for Migration, the Ministry of Foreign and CARICOM Affairs, the Trinidad and Tobago Coalition of Service Industries, the International Labor Organization Decent Work Team and Office of the Caribbean, and the Trinidad and Tobago House of Assembly Division of Community Development, Enterprise Development, and Labor. The majority of responses for this call for comments noted that the Act had no modern relevance to the stakeholder operations. The National Stakeholder Consultation was attended by 119 persons who represented worker organizations such as the National Trade Union Center, the Joint Trade Union Movement, employer organizations including the Trinidad and Tobago Chamber of Industry and Commerce, the Employers Consultative Association, government agencies, notably the Ministry of the Attorney General and Legal Affairs, the Ministry of Trade and Industry, the Law Association of Trinidad and Tobago, the National Tripartite Advisory Council, the Equal Opportunity Commission, the IOM, and the ILO. At the National Consultation, Mr. Vice President, there have been a majority support by stakeholders in favor of the repeal of the legislation based on all of the reasons mentioned earlier. One of the issues that we sometimes forget is that of the 200,000 people who went to the Panama Canal between 1884 and 1914, that approximately 4,500 of our brothers and sisters did not return to their native lands because they died essentially of malaria and/or work and HSE issues in building the canal. So this bill, which was draconian to say the least, really prevented people from looking after their lives or loss of it in one way, and livelihoods. And I think that in 1921, it is really the duty of the government and the opposition to ensure that all citizens have full enjoyment of their fundamental rights and freedoms. Citizens ought to be afforded the choice to pursue employment and other opportunities abroad. As the Indian politician Vayala Ravi once said, migration, whether immigration or return at the micro level, is an individual choice, and government has a role only to facilitate the decision of the individual. As a modern democratic society that has proper respect for the rights of individuals, archaic legislation ought not to remain on our statute books, thereby binding us to our colonial past. We must be progressive, and legislation must respond to and treat with modern circumstances and challenges. This is a move that has the approval of stakeholders, and I therefore strongly urge the members of this Honourable House to support the passage of this bill so as to repeal the Foreign Labour Contracts Act. I thank you, Mr. Vice President, and I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled an Act to repeal the Foreign Labour Contracts Act, Chapter 8811, be now read a second time. Senator Mark.
Thank you, Mr. Vice President. The matter that we are addressing, as the Minister has identified, deals with an act that is almost 121 years old, known as the Foreign Labour Contracts Act. Now, no one can argue, Mr. Vice President, that this piece of legislation emerged when Trinidad and Tobago was a crown colony under British colonial rule. Now, the Minister did indicate that when we talk about foreign country or foreign countries, the legislation at that time and what is before us only considered Commonwealth or countries within the Commonwealth to really qualify, and laborers would consequently benefit in any kind of outward migration. Now, the Minister also indicated, Mr. Vice President, that it was sometime in March of 2019 that a consultation was held to review this act. And he mentioned that over 119 persons participated and a number of organizations. I did not get from the Honourable Minister in his presentation whether the trade union movement represented by JTAM and the National Trade Union Center, what was their position on this particular piece of legislation. My information, and the Minister can guide me on this one, was that at the material time when this matter was being reviewed, there was the view expressed that the legislation ought to be amended rather than to be fully repealed. But I stand to be corrected because I did not take part in those consultations that were held in March of 2019. But having regard to what is being proposed here, And again, having taken into account, Mr. Vice President, that in a modern democratic state, where Trinidad and Tobago has a constitution, there are fundamental rights and freedoms, particularly as it deals with freedom of movement of citizens in and out of our country. The fact that we are a signatory to the Universal Declaration on Human Rights, and there is a covenant, as the minister said, that addresses at the United Nations level civil and political rights that would encompass all these fundamental freedoms, including movement and assembly. The question is, we are repealing this piece of legislation. But what is the minister putting in place or putting in its place to ensure that the rights, the human rights of workers are in fact safeguarded and protected? Mr. Vice President, we know that in Trinidad and Tobago today, contractors, recruiters come to these shores, or today they may be doing it virtually, to recruit our nurses. Even in today's papers, we have the president of the Trinidad and Tobago Registered Nurses Association speaking to the issue of close to 100 nurses having left this land to go on towards greener pastures. Now, the question that has to be asked is, what mechanisms are in place, Mr. Vice President, in this modern period to ensure that workers, laborers, skilled personnel who are leaving our shores to go into other jurisdictions, whether it is the United Kingdom, Mr. Vice President, whether it's the United States, whether it is Canada, what mechanisms, what protocols, what regulations are in place to ensure that the rights of our workers are in fact protected and safeguarded? Mr. Vice President, what kind of relationship do we have with the authorities in the United Kingdom, in the United States, in Canada, to ensure that when our people, our professionals leave here, at least their human rights are protected and safeguarded? Mr. Vice President, you know that there are citizens who have left here and they have gone to the Middle East to work, whether in Saudi Arabia, whether in Kuwait. The question again that arises is whether there are mechanisms in place to protect these workers when they migrate to other lands, Mr. Vice President. And we were hoping that the minister would have shared with this Honourable Senate, yes, there's a proposal before us, there's a policy decision before us in the form of this bill to repeal the Foreign Labour Contracts Act. Yes, that's a fact. But in repealing this particular act, Mr. Vice President, what measures are being put in place to protect the rights of workers? Because, Mr. Vice President, today, the minister made mention of it, migration is a reality that we have to address. We have workers who are being attracted to work in other jurisdictions. And Mr. Vice President, there are workers who are being contracted to work in our jurisdiction, Trinidad and Tobago. So in this regard, I would like the Honourable Minister to share with this Senate exactly what mechanisms will the government be putting in place to ensure, Mr. Vice President, that citizens who migrate to work in other jurisdictions, what kind of protection, what kind of mechanism, what kind of protection do we have in place for those workers who are migrating to other jurisdictions? I think this is very critical and very vital for us to understand. And Mr. Vice President, I know that the Minister has chosen this piece of legislation. But Mr. Vice President, there are many other pieces of legislation that we have inherited from the colonial system, from the colonial authorities, that are impacting negatively on the human rights of the citizenry of our country. And I wanted to ask the Honourable Minister, what is the government doing to deal with these matters? So, for example, Mr. Vice President, there is a colonial piece of legislation called Workmen's Compensation Act, the Workmen's Compensation Act. But this is an outdated piece of legislation. And the government should be telling us today, through the Minister of Labour, Mr. Vice President, as a colonial relic, does the government intend to repeal that Workmen's Compensation Act and replace it with a modern Employee Injury and Disability Act? I would have thought that the minister would have been doing what I call, or pursuing, Mr. Vice President, a more holistic approach, looking at those pieces of labor legislation that are detrimental to the advancement of the human rights of workers in this land of ours, Trinidad and Tobago. So I ask the minister whether there is any intention on the part of the government to address this particular issue. And Mr. Vice President, the government is moving to repeal this 1900 piece of legislation. But we also have on our books, on our law books, a law called the Retrenchment and Severance Benefits Act that does not really benefit workers when these workers are retrenched. When companies go into receivership or liquidation, they go home, Mr. Vice President, without any severance payments. So I would like the Honourable Minister, in replying, Mr. Vice President, to tell this Honourable Senate what is in store for workers as it relates to repealing the Retrenchment and Severance Benefits Act, Mr. Vice President. And Mr. Vice President, can the minister advise us whether in 2021, we are debating this matter today, whether prior to debating this measure did the minister engage in any further consultations with the relevant stakeholders? And I'm dealing essentially here with the trade union movement, the labor movement, because this legislation, Mr. Vice President, focus on the working man and woman, focus on the laboring classes, Mr. Vice President. So if this legislation that we are repealing that deals with labor rights or labor relations involving laborers and workers, one would have thought, Mr. Vice President, that our Minister of Labor would have consulted with the trade union movement and to get their thinking on this particular measure that we are dealing with today. Because I listened very closely and carefully to the minister's statement, and nowhere in his statement did he indicate to this Honourable Senate any agreement or disagreement involving Natuk and JTAM and Phaitong when they had this consultation in March of 2019 towards this piece of legislation. Did they object, Mr. Vice President? Were they in support of the repeal of this legislation? Did they put forward alternative proposals? The minister did not tell us. So we don't know what was the position of the National Trade Union Center on this piece of legislation back in March of 2019. We don't know what is the position of the National Trade Union Center and JTAM and Phaitong. And now, Mr. Vice President, in 2021, November, we are repealing this piece of legislation, and we don't know what is the position of the trade union movement. As a matter of fact, Mr. Vice President, I have been advised that the Minister of Labor and his ministry had no consultation whatsoever with the National Trade Union Center and with the joint trade union movement on this piece of legislation that is before us today. Now, Mr. Vice President, in principle, we may not have a difference or a fundamental difference to the matter that is before us, but we must be informed by the thinking and the views of those who are going to be affected either directly or indirectly by what we are debating today. And it is very unfortunate that the government did not find it fit or did not see it fit or appropriate to consult with these very important stakeholders that I've mentioned, JTAM, NATU, and Phaitong. The Joint Trade Union Movement, the National Trade Union Center, and the Federation of Independent Trade Unions. So this is a matter of concern to us, and I would certainly like the Honourable Minister to indicate why this matter was not raised with the relevant stakeholders, in this instance, labor. Mr. Vice President, I also would like to ask the Minister, we are repealing this piece of legislation because it is archaic, it is outdated, it is not relevant, particularly in a period of universal declaration of human rights and movement into and out of countries. It is coming at a time, Mr. Vice President, when migration and migrants and migrant workers is on top of the agenda. In fact, Mr. Vice President, I think there are over 200 million people, or even more, in the world today that have left their country to go into other countries through migration in order to find a better life, in search of a better quality of life, in search of a higher standard of living. So that is something that the human spirit will always soar towards. Greater opportunity, greater exposure, so that they can improve their living and their working conditions, that they can improve their quality of life and standard of living. So that is important, Mr. Vice President. But I would like the Minister of Labor to share with this Honourable Senate why in 2021 the government of Trinidad and Tobago, Mr. Vice President, would have foreigners manning the Boko Reef, the boat called Buko, the ferry, and the APT James, Mr. Vice President. Mr. Vice President, do you know that it is foreigners who are taking out foreign exchange from our nation treasury, who are now responsible for manning those two ferries in our country? And I would like the Minister of Labor to explain to this Honourable Senate, as we deal with this question of foreign labor contracts, is the Minister aware that there are foreigners in Trinidad and Tobago operating on these ferries between Scarborough and Port of Spain at the expense, Mr. Vice President, of qualified nationals who are trained, who are skilled, who have the talent to run and to manage and to command these ferries that are now under the control of foreigners. So here it is, Mr. Vice President. We are repealing a measure today that deals with foreign labor contracts. And the very government that is seeking to do so are in fact promoting at the same time foreigners over and at the expense of nationals of Trinidad and Tobago. So what do we have, Mr. Vice President? Do we have colonialism in reverse? Have we just gotten rid of the British colonialists and we have replaced them with Trinidad and Tobago colonialists? What's going on? This is a very serious matter. And I would like the Minister of Labor to share with us what is going on. Mr. Vice President, do you know that in our country today, you have a work permit arrangement that allows a company to bring in a stranger, a foreigner, into our country and to work for 28 consecutive days, Mr. Vice President, without a work permit? And then they can apply to get a more permanent work permit without any intervention from the workers who are and the unions and the companies that are affected. And these are matters I would have liked the Minister of Labor to address. Because that can happen, Mr. Vice President. What is happening in our country today with foreign workers coming in here to replace nationals cannot take place in the United States, cannot take place in England, cannot take place in Canada. But we in Trinidad and Tobago are facilitating these foreigners coming here on contract, and they are replacing our nationals. So it is a bit contradictory. It is almost ironic that we are debating a bill that is going to replace, Mr. Vice President, a system that seeks to grant permission formally from the governor in the current legislation. The president, you must get the express permission from the president to go and work in another country that is not within the Commonwealth of Nations. That is what we are addressing today, Mr. Vice President. And we have, as I said, a very unfortunate situation that is occurring simultaneously in our country and our nation, Mr. Vice President. So yes, we understand, what was taking place. We understand why, this is taking place, and this has been taking place. But Mr. Vice President, when you go through the legislation, you realize that even though we were under colonial rule, and even though you were prohibited in moving without the express permission of the president, the reality is that the laborer had a contract that was drawn up. And that contract that was drawn up in the legislation that we are about to repeal, provides certain conditions that the employer or the agent of the employer must have met, must have satisfied in order for him to get that laborer out of Trinidad and Tobago into another non-Commonwealth jurisdiction. I remember looking at some literature, Mr. Vice President, on this very bill this very act that we are about to repeal. And some of the countries that the government at that time, the colonial government, prohibited any recruitment of labor going to Liberia, Brazil. I saw Curacao, which they called the Netherlands, West Indies at the time. I saw French Guyana at that time, because they were not within the Commonwealth, Mr. Vice President. And therefore proclamations were made seeking to ensure that laborers do not go to those countries. And if they did go, Mr. Vice President, they had to get the express permission of the governor and, under the independent Trinidad and Tobago, the president of our country. So these were some of the challenges that we had to face. And as the Minister of Labor shared with us, Mr. Vice President, the living and working conditions at the time when this colonial legislation was formulated and promulgated were very, very harsh, very oppressive, very dismal for the people at that time. The literature is revealing that at that material time, Mr. Vice President, the population in 1888, 1894, 1900 was just about 270,000 citizens who occupied space in our land called Trinidad and Tobago at that time. And we were developing the oil industry, at that material time. The plantations were still in existence at that point in time because slavery and the slave trade had been abolished in 1834 and formally abolished in 1838. And within that period of 1838 and 1900, when this bill came and when this ordinance was proclaimed and promulgated, the then colonial authorities sought to attract the Portuguese to come in as laborers to replace the African slaves who had gained their freedom through the abolition of the slave trade. And they went on to see if they could attract the free Africans from Africa and from the Americas to come and work here. At that time, Mr. Vice President, they also brought the Chinese at that time. But they were no substitute for the Africans as a result of the abolition of the slave trade at that particular point in time. So you know, Mr. Vice President, what the colonialists had to do in order to continue their exploitation and oppression of the people to extract wealth for their United Kingdom at that time, because they were the colonialists. They went to India and they brought indentured laborers. So the indentured replaced the slaves on the plantation who allowed their freedom after blood, sweat, and tears and major struggles. And as the minister shared with us, many people, Mr. Vice President, left here. In fact, the literature is showing that between the period 1888 to about 1914, over 200,000 West Indians left the West Indies, including Trinidad and Tobago, to go and work on the railways and to build the Panama Canal at that time. Over 200,000 people left. And again, Mr. Vice President, it had to do with the fact that people were seeking new opportunities.
Mr. Vice President, on a point of order, please.
To improve their quality of life.
Mr. Vice President, on a point of order, please. I think the Minister of Labour would have gone through a lot of this, and I'm just wondering the relevance of the present speaker, Standing Order 46.1, the relevance of his contribution to this debate.
Mr. Vice President.
Yes, Senator Mark, so you are skirting quite wide in relation to responding to what the Minister of Labour would have spoken about in his contribution. So I'd ask you to tighten it up and come back in to what we're dealing with here, which is the repeal of that act.
Mr. Vice President, I just want to bring to your attention.
Senator Mark, 1 second, and responding specifically to what the Minister of Labour would have indicated in his contribution. Continue.
I don't know if you remember, and I don't know if my friend who raised that standing order, which, as I said, I'm obeying what you have said, but I just want to advise Mr. Vice President. The Minister of Labour made reference to the Panama Canal. So I am responding to that matter by just elaborating on the experience that we had and why, for instance, at the particular time, the bill that is before us, that is seeking to repeal the act, prohibited people from leaving Trinidad and Tobago. And the minister indicated that the foreign, when they talk about foreign, they were referring to non-Commonwealth countries. You couldn't leave Trinidad and Tobago unless you were going to a Commonwealth country. So I was just elaborating on what the minister himself had shared with this Honourable Senate. I believe that my colleague is not aware of this historical context and experience that we have been, we have been exposed to as a nation. So, Mr. Vice President, I will proceed according to your intervention. I want to indicate, Mr. Vice President, that given the current situation that we are faced with in Trinidad and Tobago, I think that we need to get legislation to facilitate the migration of citizens with the relevant protections to other lands. Mr. Vice President, just as in the 1800s and 1900s, today Trinidad and Tobago has high levels of unemployment in our land. We have high levels of poverty in our land. We have people crying out for greater opportunities in order to gain and improve their quality of life. Mr. Vice President, I don't know if you're aware, but today as we speak, there are close to 8,000 UE graduates
Senator,
who are unemployed in our country.
You have 5 more minutes.
Mr. Vice President, do you know this? As a former graduate of UE, I am a former graduate of UWI. We have over 8,000 people under this government who are unemployed and they are skilled. So I really want to appeal to the Minister of Labor to bring legislation to protect these individuals who may wish to migrate to Canada or migrate to the United States or the United Kingdom. But you have to give them some level of protection because the government of this country has failed to provide the kind of employment opportunities for our citizens. Mr. Vice President, I do have to tell you what has happened in the last few years in this country with the shutting down of Petrotrin, as an example, and
Senator,
so many thousands of workers.
Senator Mark. So that's what I'm talking about in terms of going quite broad in relation to this piece of legislation that is before us. Again, confined your comments to either respond to what the Minister of Labour has put forward or just move on to another point.
President, I know I only have about a few minutes again, about 3 minutes by now. Mr. Vice President, I would like the Minister in his winding up to explain to this Honourable Senate, if I may just summarize as I bring my contribution to a close. I would like the Minister to indicate what exactly is he replacing this piece of legislation. What is the replacement? We are repealing, but what is the replacement for the repeal? I would like the Minister to share with us what is the replacement. And can the Minister share with us, Mr. Vice President, the other pieces of colonial relics called statutes that are now burdening our statute books in this country, and that is detrimental, in fact, these pieces of legislation are essentially archaic, Mr. Vice President. And I hope that the Minister will do something about repealing these pieces of legislation so that the human rights and fundamental freedoms consistent with the Universal Declaration of Human Rights and the Covenant on Civil and Political Rights would in fact be given its full manifestation and also flourish at the same time. Mr. Vice President, I would like to thank you for the opportunity to really contribute to this piece of legislation that is before us, but I await the Minister providing further clarity on some of the issues that we have raised here on this matter so that we can understand exactly where the government's policy is going as it concerns the protection of workers who have to migrate to other countries. And Mr. Vice President, in closing, may I ask through you to ask the Minister to let us know what is happening to ILO Convention 143 that deals with migrant workers. We want to know whether the government is about to ratify Convention 143 and Convention 129 dealing with seafarers. These are very important conventions that will deal with the rights of workers in our country. Mr. Vice President, I thank you for giving me the opportunity to speak.
Senator Lachmidial.
Thank you, Mr. Vice President, for recognizing me to contribute to this debate on very short two-clause bill brought here to revoke to repeal the Foreign Labor Contracts Act. Indeed, as it has been described, one of the colonial relics that remain on our statute books, not really applicable to, or not being used, and really out of touch and not applicable to what our modern society views as labor issues. But, Mr. Vice President, let me just say, and I will pick up a little bit on what Senator Mark spoke about without repeating it, but this is a lost opportunity, really, to be proactive and bring modern, state-of-the-art legislation to deal with labor issues which are inherently linked and arise as a result of migration. There are many labor issues which currently exist in our country and around the world. And some of those issues have really been exacerbated in recent times by the COVID-19 pandemic. Increasing poverty, job loss, lost opportunities, and so on has really forced a lot of migration. But not just COVID. We've seen, for example, where you have ethnic conflicts in various countries, you've seen mass migration. And once you have mass migration taking place around the world, you are going to have labor issues because, of course, migrants would, not just move around to find somewhere to live, but they have to work and they have to earn a living. And, of course, a big part of the problem that migration would pose to any country that is the receiver of migrants would be the impact on the labor market and how you deal with those situations. Now, this particular piece of legislation that is being repealed here today didn't really treat with migrants coming into the country. It dealt with, at the time, persons trying to leave the country for greener pastures. But as I said before, simply coming to say, well, we don't need that anymore, and we're revoking it, we're repealing it, really misses the mark, in my view, because what we really ought to have had, if we went to great lengths to have public consultation and so on this, it ought to have been addressed in the minds of some of those 119 people who attended that consultation and that whole list of people who attended and organizations that were represented, that modern legislation to deal with labor issues as it pertains to migrants really is something that we need to have. So just as the colonial masters, would have looked at labor flight and so on, and there was many mega projects taking place during the period of time that this law was really being used, we too have to look at how the regulation of the labor market and migration can really how it impacts upon us protecting the human rights of our citizens as well as those who may be coming into the country, how you want to treat with issues linked to migration and the labor force, such as the proliferation of human trafficking, and that's a phenomenon that we are constantly battling with in this jurisdiction due to the influx of migrants. And you also have to consider things like forced labor, specifically as it relates to the more vulnerable populations, young people, women, and so on. You have issues as well that are globally recognized, such as equality of pay. Are you creating a situation when you have migrant labor coming in or going out where people are providing an alternative workforce, a cheaper labor force, which is exactly what happened in the 1900s. You were looking for the cheap, most affordable labor to work here, and you didn't want them to leave because you were able to exploit them. The colonial masters were able to exploit them here. What we don't want to happen now is that you have people here now exploiting another group of migrants, or that our own people seeking greener pastures, because of course we are, and I don't think anybody can deny it, we are in difficult economic times. And when our citizens choose to leave, of course we don't want a piece of legislation that says you can't leave unless the Queen or the President or the Governor General or anybody tells you can leave, but you want to have systems in place to understand that they will not be susceptible to hardship, to being, ripe prospects for exploitation when they travel to foreign lands, simply because the labor market in Trinidad and Tobago, the economy and the situation that they find themselves in is not the best at the moment. So, whilst the Act is a colonial relic, however, there were protections included in that law, and I have to make specific mention, as outdated as they are and inapplicable as they may be now, Sections 5B of this law that we are repealing, for example, dealt with the ability of a labourer to sue on a breach of his labour contract. Very important. Again, outdated, but it is something that we can look to include in a modern piece of legislation. How does a laborer recruited by an international recruiter going to work on an oil rig somewhere in Central America, which we have people doing, I actually know someone quite well who does that, 6-month contracts abroad working on rigs and so on. If his contract is breached in some way, what is the recourse? Can he, who is liable? And this piece of law, as outdated as it was in 1900s, had something that called a surety, and it was basically a mechanism put there to ensure that the laborer who found himself, on the bad end of a deal or something like that of a contract, would have some recourse against someone, whether it be the recruiter, the employer, whoever it is. We have to remember that sometimes our own citizens who may leave this country to go abroad to work, they may not be familiar with the laws, they may not have the funding and so on to be able to navigate the legal systems in the country in which they go to. Where can they enforce that contract? Would they have any recourse in the courts of Trinidad and Tobago? Would they have recourse in a court abroad? What kind of assistance would be available to them? Those are all questions that you want to consider when you're simply repealing a law that offered some level of protection, albeit not sufficient, and again not really modern in its formulation, but you still want to have questions like those answered. The law that we are repealing also went on to specify what should be included in a labor contract when someone was being recruited to go abroad.
Senator Lakshmi Dayal, 1 second. So I'm allowing you to develop the context by which you're going into what we're debating here today, but I do not want you to go too far into the legislation itself that we're repealing, because it starts to take on an act of redebating that legislation. I understand the points that you're making. Make them succinctly, specifically because you end up also repeating what both the Minister of Labour and the Senator Mark has said in rebuttal to that. Don't go over it too much.
Sure.
If you have new points, bring those forward and try not to redebate the act that we're repealing too much.
Understood. Thank you. And so, yes, Mr. Vice President, so I'll just quickly say that Section 7 and 8 of the Act we're repealing deals with what the contract should include, as well as the explanation of the contract. And why those things are important, again, it's because the persons who are most vulnerable and who require protection from a law like this, or a modern version of this law, would really be people who may not understand the terms and conditions that they're going to. I'm sure most of us growing up would have heard the anecdotal stories of indentureship, our foreparents who were promised, this land of milk and honey that they were coming to. And when they came here, they found out that the contracts weren't really, what they were, the terms and conditions that they had to work under weren't what was didn't really materialize when they got here. What they met here was something completely different. And, the ability for repatriation and all of that. And we've heard these things over and over. We taught it in history. We don't want history to repeat itself in a modern version of that, where persons are entering into labor contracts to go abroad and they do not understand the context. And I'll get into some examples of countries that have legislation that deal exactly with these things in a modern way. So that we agree, and I agree, that a restriction of movement that is in Section 3 of this clause really does not align with the rights and privileges under our Republican Constitution. But we cannot ignore those protections and the need to, have to highlight the migration issues and the need to institute labor protection. The minister made reference, and I wasn't aware of the statistic. I had heard of it, but I wasn't aware that almost 4,500 people had died, of our nationals had died in the construction of the Panama Canal when this law that we are repealing was in effect. Again, that really does highlight why we should not simply be repealing, but replacing. Because if it was HSE issues and health issues like malaria, I think it was he said, that resulted in 4,500 of our nationals dying abroad, then that in itself is the justification for why this should be a repeal and replace, and not simply a repeal of an existing law. Now, I just want to get a little bit into the issue of why it is so important to have this, and it really is found if you look at the statistics worldwide. Of course, we have a little challenge locally in terms of making these arguments in a local context because of the unavailability of statistics. But what applies around the world, certainly we can extrapolate from it and know that how pertinent it would be here. The International Labour Organization estimates that about 169 million migrant workers exist around the world, and about that constitutes almost 5% of the labor force. So migrant labor, people who leave their home country and go abroad to work or are forced to migrate because of war, famine, poverty, whatever it is, or just simply seeking better opportunities. That's about 5% of the global workforce. I found a 2021 document from the International Labour Organization called Global Estimates on International Migrant Workers. And interestingly, what I found in that report, and they mentioned, is that there's an increased percentage, whereas the majority of migrant labor is between the 25 to 69, what they call the normal adult population. The size of that grouping of younger persons below the age of 25 is actually increasing. So what you're seeing now is a trend where more young people are also joining that, what we call the migrant labor workforce. Again, to me, this underscores the need for...
I rise on a point of order, 46.1. While we appreciate the senator placing this in a historical context, I would prefer. I'm sure the senators, this House, this Senate would prefer if she stay within the parameters of the bill.
So, Senator Lakshmi, again, I'm trying to find where you're going in relation to what you're saying.
Can I explain? Sorry. Can I say? Well, it's not historical. It's actually this year, 2021 data that I'm referring to. And where I'm going with it is I'm going with why bring a two-clause bill to repeal an existing law and not replace it in the context of the importance of having modern legislation to govern migrant labor. That is the point.
Okay, so I understand that point. Now, understand what I am saying in the sense that repeal and replace is a point that has been brought up, one by the speaker before you, and that's why I'm indicating too that if you have new points, bring them forward specifically, because what you're doing is you're coming with data to make a point that has already been made before. So if you're going along the lines of repeal and replace again, there's no need to come with all of the data and all of the information that you have, because that point has been made and you would run afoul of the standing order in relation to tedious repetition. If you have new points, bring them forward now. Continue.
But Mr. Vice President, I know we aren't very data-driven in our approach, which is probably why we are repealing and not replacing. I would just want to say that with respect to the protection of human rights, there are several ILO conventions which the United Nations has called upon since the year 2013, when there was international high-level dialogue on international migration and development. They have called upon all countries to implement the relevant ILO conventions which would deal with migrant labor.
Mr. Vice President, please, 46.1, please. The bill is being repealed because it is now irrelevant, and the member is now being irrelevant.
Well,
It is
Mr. Vice
irrelevant.
President, the bill, I'm trying to make the point that the bill is not irrelevant, and that's so, and it's not irrelevant to repeal a piece of legislation and not have something in, and why it is necessary to have legislation like this.
So, Senator Lachmidial, this particular piece of legislation is a tricky one. It's 2 clauses and it's a repeal. The Minister of Labour, in his contribution, would have given reasons as to why this piece of legislation seeks to repeal. Senator Mark, in his contribution, would have responded to those reasons put forward by the Minister of Labour. The problem that you're encountering is that you are using other pieces of information to repeat what Senator Mark would have indicated. And that is where you're going to run afoul of not just relevance, but tedious repetition. So that is why I'm indicating again for the last time, if you have new points outside of you need to replace instead of just repeal, I invite you to do so now. Otherwise, you're going to continue to run afoul of the standing orders.
I understand everyone isn't very comfortable with academia, but let's just get on with it then. Legal migration, Mr. Vice President, and legal channels that are regulated properly for migration could actually affect labor market needs, and they should reflect the labor market needs. What we are...
It's either that I am not being clear. So we're not talking about labor market needs, and we're not talking about repeal and replace again. Do you have new points to bring forward in relation to anything that the Minister of Labour has said outside of what has been already responded to by Senator Mark? If you have new points, bring it forward now so that you can continue in your contribution. If not, then you're going to run afoul of the standing orders. It's a very tight piece of legislation.
Mr. Vice President, can I go through some examples then of countries that have legislation that deal with these issues?
That's the thing, Senator Lachmidia. There's no need to go through examples of countries that deals with that. Senator Mark dealt with it in terms of the need to replace it with something else. You cannot go through that in terms of examples of countries that have legislation that may have or may not have replaced this piece of legislation that we're trying to repeal. And that's why I'm indicating to you, you need a new point. If you have a new point, by all means, you may continue. If not, well, then you have to decide how it is that you're going to couch this or bring this across so that at least it brings something new to the debate.
Well, Mr. Vice President, I would simply say that it's a complete and utter waste of parliamentary time to repeal a piece of legislation and not propose something new to deal with serious issues that affect this government, but clearly the government isn't interested in hearing about proposals for a modern piece of legislation that deals with labor issues in this country. They are quite content to note that migrants, given the extenuating financial circumstances they find themselves due to the mismanagement of the economy by the government, might be fleeing our shores to seek opportunities abroad and would have absolutely no protection under the laws of Trinidad and Tobago. Thank you.
Senator Dayal Singh.
Thank you, Mr. Vice President, for allowing me to partake in this.
Yeah. Can you please use the booth?
Okay, sure. Thank you. I thank you, Mr. Vice President, for allowing me to partake in this debate this afternoon. And I want to thank the Minister of Labour for bringing this piece of legislation here, the Foreign Labour Contracts and Repeal Bill 2021. Mr. Vice President, the Article 13 of the Universal Declaration of Human Rights states that everyone has the right to freedom of movement and, residence within the borders of each state. And it also says that everyone has the right to leave any country, including his own, and to return to his country. So therefore, if we are to look at this Declaration of Human Rights, this piece of legislation, this old legislation that we had there, certainly would have restricted the movements of our citizens to move outside of the country. And we got a good history from the Minister of Labour in terms of why it was necessary, the labour moving out, and also we heard the ill effects of some of our citizens who faced the burdens of disease, malaria, etc. in the Panama Canal, and probably other countries too. So this bill here, this repeal of this bill serves to really allow this movement. So we cannot really be expected in this day and age with the global movement that we would want to restrict any sort of our citizens from moving to be shackled by an old sort of colonial legislation, which probably at the time it would have served its purpose. So again, I thank the Minister for bringing this, and I want to say that, the description of when we looked at the description given by the dismal working conditions, and some people, looked at that working conditions, the working conditions that existed, and the need to leave. Sometimes we have working conditions in Trinidad which might still, in certain aspects, in certain communities, that might still leave people wanting to leave. And I'm thinking that, Section 3 showed the need to leave to go abroad, and the fact that people would have wanted to go abroad, there's still that need here. And there are still poor working conditions, Mr. Vice President, that I must just make mention of one quickly, that if I look at even the labor force, when I look at the CPEP workers, Mr. Vice President, they're doing an excellent job. But when I see they working in my community and they have no portable water in times of COVID or portable toilet in some sort of truck that they can carry, I look at them and say, hey, if I were in that position, I would want to go to a place offering better working conditions. So we have to look within our system how we could also improve our labor force, our workers, to give them that benefit of such a peace when they're working in terms of any sort of lack of hygiene or mention. So when I look also at the fact that in terms of the freedom of movement, we saw in the European Union that also came about, that the need for that freedom of movement. Just as how we are now freeing up our citizens, the European Commission, when that came about, they actually said the persons within the European Union could have that freedom of movement. And again, our freeing ourselves of this bill also reminds me of the free movement of workers, which was a fundamental principle in the treaty enshrined in Article 45 of the Treaty of the Functioning of the European Union. And it was developed by the European Union as a secondary legislation, and also by case law. So therefore, the need to look for a job in another country, the fact that you could work there without work permits, the fact that you could reside there for that purpose, stay there even after the employment has finished. And the Minister did mention the CARICOM workforce, that we have now that freedom of movement. This is something commendable that we can also look forward for this. But I also would be hoping, just as how the European nationals could now stay in the country of work, we may have to develop that within our CARICOM community also, that we could go and work in Barbados or other country and stay there. So we are now, in my opinion, having this repeal shows that we are looking at the global situations. We've seen what's happening in Europe. We see what happened in the international conventions. But I must make mention that, we in Trinidad, we have looked at the labor force, and we do have business persons, other persons complaining they are struggling to get Trinidad workers in their labor force. And some of them are even hiring the migrant Venezuelan personnel. So this is a fact, be it the salaries are less, be it they get greater work ethic, whatever. So even if we have when we have this bill repealed and we have more freedom of movement, I'm just wondering, would we now be faced with a situation where our own persons here would be now having a poverty of people in the labor market? So we have to get better, we have to realize one of the fallout of this repeal would be a further migration of our workers, and as a result, greater level of despair among persons who want to hire local persons. The Venezuelan workers, sir, doing a good job, but the European Union, I must mention the fact that they also said that the workers must enjoy equal treatment with nationals in access to employment, working conditions, and all other social and tax advantages. And why I make mention of it, because Senator Widmark did mention that the protection of our workers outside is also important. So I had also brought up this similar situation when some members, I think it was 103 members, were actually trapped in Canada, in Ontario, during the COVID period when the work had stopped and those workers, they couldn't return to Trinidad because of the lack of getting PCR testing and whatnot. So while Senator Mark made that concern, and it's a valid concern, we have people out there sometimes, I had made a suggestion that, and I'm making this suggestion now because it was raised, that our embassies could play a more important role. Any of our workers go out there, we can track them. We have the technology where we can track our workers. They can actually be in contact with the nearest embassy. And if there is any sort of failure or any sort of concerns, we have our people out there who will be able to look at the welfare of the workers. So this is not a problem that is unsurmountable. So there may be laws within the countries to protect workers, even foreign workers, but there may be also our own embassies out there will be able to play a greater role in protecting our workers. So this is something I'm thinking that we may have to get in our Minister of Foreign Affairs to get that on board. So anyone go in there. I had a patient, sir, who went Japan to work. And that patient actually...
Okay, so Senator, you've made that point, and I've allowed you to sort of give a solution to some of what has been raised. There's no need to go further.
Sure. So, thank you, sir. So what I also wanted to mention, Senator Widmark had mentioned that the fact that the University of the West Indies would have had persons on board who would also be wanting to go out of the West Indian environment. And I'm saying I have to make mention that we are doing an excellent job in terms of our education. We had, it was really the dream, I think, of our first Prime Minister to have an educated public. And I'm happy to say our UB graduates, we are among the top universities in the world. We are among the updated ranking is 2.5% in the universities. So what I'm saying is we also have to give knowledge to the fact that our university graduates may also want access to go outside, freedom of movement. We also have to bring into the fact that we have a lot of scholarship winners who are still working for jobs. We may now be able to say, well, we have this freedom of movement that we go on. So when I'm thinking that, okay, people want this freedom of movement, we think that it's a basic right, but we have to understand we are still under the fact that, the vaccine passports, the COVID vaccine passports are there, so it's not really a free movement that we may think. We still have to have that movement within other laws. So I also support this piece of legislation, not because it is just outdated and I'm seeing we are helping persons, but the fact is it could serve as a source where people can go abroad and earn foreign currency, because we have been seeing a lot of complaints of Forex, people not getting foreign currency. So again, this is an avenue where we can now get our labor force out there, be it in the Guyanese market, wherever, that we can have the idea that people could bring back that money, send that money to their relatives once they are working out of the foreign currency. So again, that's a great advantage. So I welcome this move. And like Senator Mark, I would have rather gotten some idea about the 119 persons who were consulted. You know, it's easy, sir, to have a consultation, and you say, well, we consulted with 119 persons. So in things like this, government should actually give us the dissenting voices. So we might have been able to judge better. Well, you know, probably the unions disagreed with a certain factor about it. So I'm thinking in future, when we have pieces of legislation like this and government has consulted, to leave that out, give it to the public to be able to have a discernment. And is it something we are missing? Because we could be missing a valid concern as somebody could have brought up. I also want to make mention that the fact is, when we are looking at the made mention that the labor force, you know, I think Senator Lochmedial made mention about the endangered labor force scheme in here. Yes, our forefathers did migrate here. We came here for a better promise. And again, I think because of that, we should be willing to support any piece of legislation who could give any Trinidadian the opportunity to go elsewhere, make themselves in a better condition, and to support their families and sometimes support their country. I thank you, Mr. Vice President.
Thank you, Mr. Vice President. Mr. Vice President, this repeal of the Act today is really a simple exercise, and I'm surprised that it was complicated so much. There seems to be a misinterpretation of what we are doing here today. The Act generally restricts movement from people leaving the Twin Islands state of Trinidad and Tobago. And I hear talk about replacing it. So do we replace an archaic law with a draconian law? Are we going to do, what do we really want to do? But Mr. Vice President, let me just put on the record a couple of things that came out. There was a lot of good talk, but not relevant talk. I would like to put on record that yes, FITAM and JTAM and NATOC was in fact in relation to Senator Wade Mark's query whether the unions were involved. Yes, they were involved, and yes, they agreed to repeal the Act. I hear the concern of the opposition and the senators about what do we replace this with. And I just want to say that there are a number of legislative items that would be coming in short order with regards to the Recruitment of Workers Act, the Trafficking in Persons Act, the Workers and Employment Standard Act, and the Workmen Compensation Act. These acts, in and of themselves, really reach into many of the areas that persons wanted to bring up in regard to what's happening in the world today, where how do we, in fact, deal with issues coming out of the international labor organizations, the different treaties, and so on. And all of that, Mr. Vice President, will be done in due course. But today, what we are tasked with is repealing a piece of archaic legislation that limits the outward movement of people from Trinidad and Tobago. And therefore, the other issues that have been highlighted are not necessarily relevant at this time. So, Mr. Vice President, I don't think I have a lot to answer based on relevance, except to give some comfort that we are looking at legislation that will cover all those areas. And with that, I want to thank you for giving me the opportunity to respond. And Mr. Vice President, I beg to move.
Honourable Senators, the question is, Senator Lyda, are you done? Honourable Senators, the question is that a bill entitled An Act to Repeal the Foreign Labour Contracts Act, Chapter 8811, be now read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Minister of Labour.
Mr. Vice President, in accordance with Standing Order 66-1, I beg to move that the Foreign Labour Contracts Repeal Bill 2021 be committed to the Committee of the Whole, Senate, forthwith, and to be considered clause by clause.
Honourable Senators, the question is that the Foreign Labour Contracts Repeal Bill 2021 be committed to a Committee of the Whole, Senate, forthwith, to be considered clause by clause. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into Committee of the Whole to consider the bill clause by clause. Honourable Senators, this particular piece of legislation has two clauses to it, and as far as I'm aware, no amendments have been circulated prior. We shall now go through bill clause by clause.
Clause 1.
The question is that clause 1 stand part of the bill. Honourable Senators, the question is that clause 1 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 1 now stands part of the bill.
Clause 2.
The question is that clause 2 stand part of the bill. Honourable Senators, the question is that clause 2 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 2 now stands part of the bill. Honourable Senators, the question is that the bill be now reported to the Senate. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The bill will now be reported to the Senate. Minister of Labour.
Yes, Mr. Vice President, I wish to report that the Foreign Labour Contracts Repeal Bill 2021 was considered in the Committee of the Whole and approved without amendments. I now beg to move that the Senate agree with the committee report SO 69-1.
Honourable Senators, the question is that this Senate agree with the committee's report on the Foreign Labour Contracts Repeal Bill 2021. Those in favour say aye. Those against say no. I think the ayes have it. Minister of Labour.
President, I beg to move that a bill entitled An Act to Repeal the Foreign Labour Contracts Act, Chapter 8811, be now read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Repeal the Foreign Labour Contracts Act, Chapter 8811, be now read a third time and passed. Those in favour say aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Repeal the Foreign Labour Contracts Act, Chapter 8111.
Honourable Senators, at this juncture, I think it's a good time to take a small break, so this Senate will now stand suspended for 10 minutes.